Mr. Brooks will proceed as his own attorney.
It will be defendant Darrell Brooks questioning witnesses and victims. Judge Jennifer Darrell ruled today Brooks can represent himself at trial. She found him competent. Prosecutors charged Brooks with 77 crimes stemming from the Christmas parade attack. Jury selection will start on Monday.
Brooks spoke over Darrell several times, repeating his request to have a copy of her oath of office. He also asked at least 6 times for Darrell to state her name in court. District Attorney Sue Opper suggested Brooks be gagged to stop the outbursts, but ultimately Darrell moved Brooks to a nearby courtroom so he could watch remotely.
We are back on the record in State versus Brooks. Mr. Brooks, we're having issues because of you.
We're having issues
not because of me. I've made my determination. I provided you with the law.
Because I'm not going to let you intimidate me into believing
Mr. Brooks, I am not intimidating you.
Because you can't. And you see that. You clearly see that you can't intimidate me.
It is by his conduct, not the choice of the court.
No, that is judicial conduct of anything, Your Honor. I simply merely asked
be in the other courtroom, and you can take him back there. Mr. Brooks, I absolutely want you present in the courtroom, but that is for you to decide at this point.
I'm not consenting to anything you say until you can answer the questions that I'm asking.
Are you refusing to cooperate? Would you like to address Mr. Brooks?
How does me being in the other courtroom constitute prejudice?
I've referenced the law.
What is the law?
I've made my ruling. If you don't like my ruling, you can file an appeal.
I will appeal that decision, Your Honor.
I understand. I expect that.
I don't understand how I can participate in a trial from a whole nother courtroom.
That's your choice, sir. Your conduct dictates that. So if you can participate fully when you follow the rules of decorum and courtesy. When you don't do that, you lose and you forfeit that right under the law.
I don't need to be put in a holding cell not explaining why that can be lawfully done when I'm supposed to be present for all proceedings. And
you may not like it, you may disagree, but I'm not going to stop the trial because of it.
It's not about me liking it. It's about it being fair and it's about it being lawful.
So my question to you is, sir, are you going to...
No, I'm not.
All right, then you will participate. I'm going to start jury selection.
No, I will not.
And so I am going to bring the jurors in. I don't need your consent. Mr. Brooks, I've warned you.
I have to be present for every
Mr. Brooks, you will be present from that other courtroom.
No, I will not be.
That is your choice.
Can you produce a sworn affidavit that says that that's law? Can you show me proof?
All right, would the bailiffs please remove him to the other courtroom? This court is on day 1. It is 2:15 p.m. This court, within 5 minutes of starting court this morning, had to remove Mr. Brooks based upon his interruptions at that time. I've lost track, but I think I'm at least 5 or 6. Who knows, maybe more.
With the Secretary of State.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing the line,
being removed from the courtroom for continued interruptions.
I
want you here.
To that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. And it is only, it's 8:57. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disrupted.
The next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent.
We have the jurors here?
And I do not agree to anything.
Not yet.
Your Honor, just from the
With that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks.
in her possession.
No one's going to be answering these questions. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move the court again.
Currently, you are not muted. Mr. Brooks? All right, you can mute him. Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your lack of consent is noted. I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions regarding my name, my oath, jurisdiction. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction. I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is again once is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior. I know he had some documents and some things in front of him. At one point, I saw him sort of do a sweeping motion and things seemed to go flying. I'll get some verification of that, but he will at least be given a notepad, a writing utensil. I've been advised that Mr. Brooks did throw some items on the floor, but he does have his paperwork and a pen.
The defendant made 2 motions to dismiss for judicial misconduct. I'd ask the court to summarily deny those motions based upon lack of merit, and he didn't provide any support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal. While that's really not something I would need to address, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. I will, just like I did yesterday, advise the jurors that Mr. Brooks is appearing from a remote location and that should not influence their verdict in any way. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise any issues with the court, he is advised to write that down. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me so that I can raise any issues of merit. All right, I can tell from his demeanor right now, he's doing a clapping type motion. He's doing it once again. It's a clear indication that he can hear this court. I've also confirmed with the bailiff and court staff that he's able to see and hear. All right, we are back on the record. Mr. Brooks, I've been told it would take maybe 15 minutes to go to your cell to get whatever that list is that you have so that I can adequately advise the potential jurors. Any witnesses who may be called in this case, you told me you have that, so I'm going to give you that opportunity. I'm going to print off the state's witness list.
I don't need it.
The issue that he's brought up with being deaf in one ear, though he didn't notify anyone he was having trouble hearing. He was answering questions in the other room without the headphones on. Actually, he was given the headphones. It took him a minute before he even thought to put them on.
I would note he does not have the headset on here. I can make a further record that previously, especially when I went through the waiver of right to an attorney, he at times would answer, "I hear you," or "I heard you." I referenced going back to your cell to get the list. Giving you that opportunity, you asked me to do that.
I did not ask you to do that. The question was, where was the list at?
So you said the list was in your cell. I'm advising you that I'll give you the opportunity
I
to
don't
go.
want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. If you choose not to do that, either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the
I'm
list?
telling you, I'm giving you the opportunity to
I'm
go
not-
get that.
I'm not gonna go do that.
Mr. Brooks, I'm not going to play games with you.
And
I'm
not-
giving you
I'm
an
not gonna-
opportunity.
And I told you that I'm
either
not
go to
gonna
your
do that.
cell and
You
get
said
the
I have the
list or
opportunity to
not.
do that.
All
You
right.
said I have the opportunity.
I'm not going to
do
demand that you do it, but you have to understand, sir, that if you
I
choose
don't
not
understand.
to do
I
that.
don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't
You
know how
claim
many
to not
times for the
understand,
record.
and that's been made very
Oh,
clear
I don't
here, sir.
understand. You're not
So-
going to get me to consent to something that I don't consent to or agree to. I do
No.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand the
take a
nature and
recess
cause
so
of
that
this.
the court can get this
Exactly
information
like I've
from
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned, once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless of me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a
preference-
joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet
Right.
to verify anything
You
by
can take
sworn
him back to
affidavit.
the other room.
You
He's
haven't
been
even honored-
disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't even
gentlemen. We'll
honored-
have to,
you haven't even
clear
done
the
that.
courtroom.
I don't agree to a stop when I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. The record should reflect that I don't agree to a stop